Senator Carter, we're live.
Good morning, everyone. Thank you to all of the members of the Joint Committee on Federal Relations for joining us this morning for the briefing. I want to open by thanking my co-chair, Delegate Carr, and the DLS staff for all of your assistance in pulling this briefing together, especially Scott Kennedy and committee staff Samuel Kist and Kamar Merritt. This committee, as you know, first of all, many of you do know because I'm new to the committee, some of you have served on the committee before, that our committee reviews and provides guidance on federal-state relations as well as interstate cooperation. And so the subject matter today is two separate issues. The first is the legal framework around National Guard deployment. The second is to look at the proposed family interstate compact for placement of children. And I will chair the first part of the meeting. We are very pleased to have a presentation by Brigadier General
Senator Carter,
Flash. Yes.
I'm sorry. Do you possibly have YouTube open?
No.
Okay.
Are you getting feedback?
We have an echo.
I'll turn my heater off. Better?
If there's a I'm sorry, there's just so do you hear that delayed? Senator Carter? Sorry, it looks like Delegate Carr, Senator Carter's lost her connection. Would you possibly be able to take over for the moment?
Okay, good morning, everybody. While
Delegate Carr, Senator Carter's lost her connection.
While my co-chair, Senator Carter, works to get reconnected to our meeting, I'm going to go ahead and get started. So again, the first part of our meeting is a briefing on the out-of-state domestic deployment of the Maryland National Guard for law enforcement purposes. Stemming from the Maryland National Guard's deployment to DC in early June, we requested information from the military department regarding, among other things, the authority under which deployments of that sort can occur and what policies or procedures are in place to ensure that Maryland National Guard forces on those deployments would not potentially receive orders from federal or another state's officials, or that they would not otherwise receive that if they were under Maryland officials' operational control. So the military department responded to our questions in writing, and they're here to give us a presentation. We have Brigadier General Adam Flash, and Ms. Catherine Kelly, who's the Director of Legislative and Government Affairs, if you all want to take it away.
Well, good morning, Senator Carter, Delegate Carr.
General Flash, I'm sorry, could I just break in for a moment?
Sure.
I just wanted to check. Supposedly that we're hearing this delay, I think, but I don't think it is on YouTube. Is everyone else hearing that delay, or is that? Oh, okay. Okay, great. I really apologize. Go ahead, General Flash.
Okay. Thank you again. Good morning, Senator Carter, Delegate Carr. On behalf of the Adjutant General, Major General Timothy Gowan, myself and Ms. Keller here, happy to present answers to the questions posed by the committee. And again, I also want to say good morning to the committee members. So the first question that we were asked with, and if we could please show the slides, that would be helpful. Okay, so the first question deals with the legal authority that the National Guard was missioned under the support to the DC National Guard. In this particular mission, we were under United States Code Title 32, subparagraph 502F, which simply allows the National Guard to move from a training status to an operational status in support of a federal mission. And that federal mission was providing security to the federal monuments under the, in support of the Federal Park Police at the DC Federal Enclave. Next slide. Next slide, please. Okay, the second question asks a broader a question about legal authority of the National Guard. And so if you're not familiar with the National Guard, we are a very flexible capability belonging to the states in 2 out of those 3 frameworks. The first framework we will respond under would be the Emergency Management Assistance Compact, where one state or territory or the district sends a request through the Emergency Management Agency for support of National Guard forces, and we would typically respond to that request in a state active duty status, which is funded by the governor, funded by the state, I should say, and then reimbursed by the requesting state. As part of an EMAC process, the mission parameters are specified, the time frame is specified, and our legal authorities, whether we're responding for a natural disaster or civil disturbance, is also specified as to what would be our role. The second framework, which I just covered in the previous question, is Title 32 502F. This is not a usual way we respond to state emergencies, but under COVID, 502F became the more advantageous status for our members because it provided full active duty benefits, including TRICARE. And it allowed for us to work under a FEMA mission assignment, which we were doing under COVID, and also to a very limited extent in our support to the DC Federal Enclave. Next slide. Framework 3 is when the National Guard is federalized by the President of the United States under the Secretary of Defense, typically for deployment to overseas missions, but also can be federalized within the United States. And at that point, the National Guard becomes as component 2 of the active Army, and so I don't want to go too far down that particular lane. But the Army has 3 components. Compo 1 is active, Compo 2 is National Guard, and Compo 3 is Army Reserve. So when we're moved into a Title 10 status, we become component 2 of the active Army and are part of the federal force. Question 3 deals with sufficient policies and procedures for those legal frameworks and asks if they're sufficient. Short answer is yes. The frameworks provide sufficient guidance for the use of the National Guard, 2 of which are under the control of the governor, 1 of which is under the federal control of the Secretary of Defense by way of the President of the United States. Next slide, please. So specifically, question 4 then narrows the focus down to how we're used out of state and domestic deployments, even if the formal mission is not accomplished. So the governor, in his role as commander-in-chief of the National Guard, retains control over the National Guard, whether it's in the state or out of the state. If we have an EMAC, the specific mission parameters are set prior to any deployment of National Guard forces, say for hurricane support or other natural disasters. And at any time, the National Guard can be recalled by the governor. At no time does our status change, either in state active duty or in Title 32 502F, as to the authority of the governor to control the National Guard in or out of state. At no time can the mission be changed by another state, territory, or district without the concurrence of the governor. And if the governor does not concur, then he has the authority, or she, in certain cases, to withdraw the National Guard back to their respective state. In the event that there's a federalization of the National Guard soldiers, then the other two frameworks are set aside, and the President of the United States, by way of the Secretary of Defense, has control of those formations. And question 5, the total cost for the deployment for the Maryland National Guard is provided $546,360, all paid for by federal funding under 502F. So that answers questions 5 and 6. Next slide, please. So question 7 deals with the legal framework of question 2 above. Do Guard members receive the same or additional pay? Again, I alluded to this somewhat in question 1. So in state active duty, the state of Maryland, and I'd like to give a gratuitous thanks to our state legislature for that support, because not all states get the active duty pay table. But here in Maryland, we pay the basic active duty pay table with a basic allowance for subsistence provided to our National Guard members serving on state active duty. The only difference between state active duty and federal active duty is that federal active duty comes with the full pay and allowance. So if there are special incentive pays that members receive, they'll get that additional pay in addition to their basic pay, and they also get a basic allowance for housing. The basic allowance for housing, referred to as BAH, is quite substantial here in Maryland because of the cost of real estate. So a soldier receiving active duty pay in Maryland will receive almost a third of their basic pay through basic allowance for housing, which is also untaxed. So that's a substantial increase in pay when you're on federal active duty. The difference is in federal active duty, you accrue retirement points. And most important to the leadership of our organization is our soldiers are covered medically. In state active duty, we are provided workers' insurance fund, which is a submission for repayment. So if a soldier has a catastrophic injury, they've got to go through the workers' insurance fund. And if that catastrophic injury results in a service-ending limitation, they could lose their membership in the military, the Maryland National Guard, and the Army or Air Force writ large without any compensation. And so that's a structural risk that we're going to try to work through in the coming sessions to see if there's other options. But you can see where 502F under a FEMA mission assignment is more advantageous to our members because they receive full military pay coverage. And when they're over 31 days of order, they get full TRICARE for themselves and their family, which was critical for our leadership to work through the governor and the governors writ large throughout our nation to push for this kind of coverage. Because, as you know, our soldiers in TRICARE, they're covered and their families are covered in a COVID environment. We felt that was the safest and most advantageous for them. Lastly, and I apologize for the length of the answer to this, but it is when we deal with pay and allowance, it's quite in depth. You also accrue retirement points while on active duty, whereas on state active duty, those retirement points don't exist. So that deals primarily with the framework and how the two pay systems, federal versus state, work. Next slide, please. How many guards, men and women? Well, we had 116 soldiers deployed in support of the DC Federal Enclave mission. Their chain of command, I won't read it to you, but we sent a lieutenant colonel in charge of the formation, and he worked directly for the DC National Guard. But at all times, that same commander was in contact with his chain of command, updating the adjutant general on a daily basis as to the mission parameters to ensure we were maintaining the missions that we had agreed to. I have a close working relationship with the DC National Guard, my counterpart. As you know, one of the great things about the National Guard is that we don't move every 3 to 4 years, and so we develop relationships and trust that we can pick up the phone and call another one-star general and make sure that our soldiers and airmen, when employed, are used in accordance with the agreement that was set forth. Next slide, please. Okay, where exactly were they positioned? So as you can see, we were at the Lincoln Memorial, World War II Memorial, and Washington Memorial, always with a counterpart being the Federal Park Police. It's important to recognize that when we are at home, in the homeland, we are in a supporting role. The National Guard is never the leading agency in any mission. And that, again, shows deference to the fact that the state is run by our elected leadership and the agencies that fall under the executive branch. Typically, the National Guard is in support of Maryland State Police or another policing agency. During COVID, we were in direct support of Maryland Department of Health and many of the missions we're doing. So in that aspect, we were there to monitor the security of the monuments, and then if there was any impact to the monuments, to contact Park Police and allow them to do their duty as sworn law enforcement officers. Interactions with the civilians, I had a chance to chat with the battalion commander of that unit, and they were largely positive. There were no unlawful acts, and the mission to keep the monuments from being damaged was successful. Next slide, please. Our injuries, I'm thankful to report that our soldiers had no injuries, and that at all times the mission was conducted in a professional, positive manner, and that our interaction with the public was predominantly positive. In question 13, we have a question about the powers of the governor to command forces activated Title 10. So the clarification again is the National Guard is a component of the United States Army and Air Force, Compo 2 of the United States Army and Air Force. That's who pays 95% of the cost of the organization. The NEICE added benefit that the National Guard brings is all the active duty training that we go to with our active duty counterparts, we bring back to the state. In addition, of course, we bring back all the federal funds that are usually 3 to 1 state dollars spent. So you get 3 federal dollars for every $1 state spent in the state. But at the end of the day, the Army and the Air Force, have oversight of the organization, and under National Guard Bureau, we are required to comply with our Army and Air Force regulations and policies. Myself, I hold a dual commission, commissioned by the United States Senate, and I'm also carry a commission in the state of Maryland. And so that dual status allows for the governor to maintain control over the National Guard, except for when the president exercises his authorized authority under the Constitution to activate the Army National Guard and Air National Guard as a reserve component of the Army and Air Force. Next slide, please. That concludes my briefing. I welcome any questions and look forward to helping clarify any questions I haven't covered at this point.
Okay, thank you, General Flash. So Senator Carter lost power, and she's phoning in to rejoin us. But if you have any questions, if you could just send me a private chat to let me know that you have a question. I will start off with a question, and I guess my question is: if the Maryland 116 Maryland National Guardmen hadn't been called up, what would they have been doing? Would they have been inactive? Would they be assigned a role somewhere in Maryland? What would they have been doing had they not been called and sent down to Washington, D.C.?
So in June, we were at a position where we were able to move some of the missions we were doing for COVID back to state agencies who were building their own capacity. And so these soldiers, had they not been assigned to DC, probably would have been continued to provide additional support to whatever COVID missions may have evolved at that time. In June, we were at the point of waiting on another presidential memorandum. So had we not had a mission in DC, very likely those soldiers would have been started the process to demobilize and come off active duty, because at the time, 2 June, we did not have the presidential memorandum signed. And so without the presidential memorandum, we would have to start to demobilize forces. Sometime in that week, we ended up getting the presidential memorandum, so we were able to extend our forces through the end of June. which allowed us to do a more graceful handoff of missions to our state partners.
Okay. So in terms of the start and end dates, the Maryland Guardsmen were there from, you said from June 2nd until the end of June? Is that correct?
No, sir. No, sir. They were in DC from 2 June to 6 June.
From June 2nd to June 6th?
Yes, sir.
Okay, so 4 days. Okay. Now, is it the case that this framework is the first time that it's been used? The framework that was used in early June, I forget what the exact statutory reference is.
So Title 32 502F, it's not the first time we've used it. In fact, it's used quite regularly for national special security events like inaugurations. We are typically in the District of Columbia every 4 years as a support element, along with 13 to 15 different states in support of the DC National Guard for inauguration operations, federal inauguration. We use it consistently for mutual aid support under our weapons of mass destruction teams that we have. There's 54 of them throughout the states, territories, and the District of Columbia, and we have a close working relationship with the weapons of mass destruction team in DC, and we are there to support them and augment them for other national special security events. So the 502F framework is used regularly for specific events outside of COVID.
And my understanding is that the request went out to all states, but not all states sent their guardsmen. For example, I understand that Virginia declined to send any of their guardsmen into DC because of that request, and that Delaware sent some guardsmen, but then reversed their decision after they learned more about the events that were unfolding. Do you think there's a potential for the public to perceive a deployment like this as being politicized when only certain states are sending their guardsmen and other states are not?
I will tell you, I don't think I'm qualified to speak to what the general public will see. I will tell you that under the framework that was set forth, we had a request, which we followed our standard operating procedures in doing mission analysis and did our best to support the DC National Guard in their mission assignments that they put through the system. So as to the other states, I can't speak to their methodology or mission assessment, but I can tell you that we did not follow any new procedures in this process. And we've worked with the DC National Guard closely in many other instances as a partner National Guard state and district.
Thank you. Now, so I understand that the Maryland Guardsmen were deployed at different monuments and memorials around DC. So do monuments and memorials need to be guarded? I mean, I can't remember that happening in the past. Is there a need for that? Do you think that is something that makes sense in terms of a use of our guardsmen?
Again, that's a civilian leadership decision that, again, is well established in the history of our country. The military is a subordinate element to elected leadership. In this particular one case, there was a concern because other monuments in the District of Columbia had been defaced. And so there was a request to provide overwatch and work with Park Police to expand their ability to view our national monuments. And so in that case, the mission was outlined to us, and we were sufficiently capable of providing overwatch of those monuments and provide the Park Police the ability to respond. In the particular case, during our 5-day mission to the District of Columbia, we didn't have a single situation where there was a defacing of a monument. Now, was that because we were there or not? I cannot speak to that. It's not within my realm of knowing.
Okay. Do we have other questions from members of the committee? All right. Well, seeing none, thank you very much, General Flash, for your presentation. We greatly appreciate it.
Yes, sir. The pleasure is mine.
All right. So moving on to the second portion of the meeting, we are going to be briefed on the Interstate Compact for the placement of children. So we are currently a member of the existing Interstate Compact on the placement of children. The new compact is called the Interstate Compact for the placement of children, and it's been adopted in 12 states, but it needs 35 states to enact it before it would take effect. The American Public Human Services Association, which facilitated the drafting of the new compact, and the Maryland Department of Human Services are here to discuss the new compact, how it's different from the current compact, and the extent of the need for the new compact. So to start off from the American Public Human Services Association, we have Ms. Carla Foltz, who's the Director of Interstate Affairs and Compact Operations, and Mr. Rick Masters, who is a compact expert with the Council of State Governments. Take it away.
Good morning. I would like to thank Senator Carter and Delegate Carr and the entire Joint Committee on Federal Relations for allowing this opportunity to speak to you about the reform of the Interstate Compact on the placement of children. As Delegate Carr already stated, I am the Director of Interstate Affairs and Compact Operations with the American Public Human Services Association, which has served as the Secretariat for the Association of Administrators of the Interstate Compact on the Placement of Children since 1974. Joining me, I also have the compact expert, Mr. Rick Masters, and I'll ask Mr. Masters to introduce himself.
Good morning, members of the committee and co-chairs. It's my pleasure to be here to talk to you and perhaps answer questions with regard to this Interstate Compact for the Placement of Children. I'm the special counsel for the National Center for Interstate Compacts, which is affiliated with the Council of State Governments, which some of you may know as the Southern Legislative Conference, where I know many of you have participated in our meetings about compacts and other subjects. But it's been my pleasure to be involved with this particular compact in assisting in the drafting of the new compact. And as you know, as members of this committee, interstate cooperation is conducted in many issues with regard to an interstate compact. And Maryland, like every other state, is a member of about 24 interstate compacts that regulate everything from the placement of children to environmental matters, to transportation issues, and more recently, compacts regarding occupational licensure. And I was up here not too long ago on the Interstate Compact for medical licensure, which Maryland has adopted, as well as the Nursing Compact and several others. So I know you're aware of this means of interstate cooperation, and I'll just reiterate that the purpose of an interstate compact is primarily for permitting and encouraging states to maintain sovereignty over things that states traditionally regulate, including things like the placement of children. And so this allows the states to collectively exercise their authority as members, as a member of a compact commission or other governing structure, which allows collective exercise of the sovereignty of the state. So we are happy to talk about this particular exercise in federalism and interstate cooperation, and I'll kick it back to Carla to talk about the details of this particular compact.
Thank you, Rick. So we wanted to do a high-level overview of why we're looking to reform the ICPC. And first and foremost, the existing ICPC was written in the early 1950s, with the first state passing in 1960, which was the state of New York, and the last state passing in 1990, which was New Jersey. So as you can see, that was a 30-year time frame for all 50 states, the US Virgin Islands, and the District of Columbia to become parties to this particular compact. That compact, of course, was drafted and developed at a different time, where there was a different infrastructure for the child welfare system. There are fundamental problems with the legal framework. We'll get into more detail about that shortly. The mechanisms, processes, the terms within this compact are archaic, antiquated. For example, you'll see terms like mentally defective in the compact, which we know is no longer politically correct. A lot of the definitions are not sound from a legal framework as well. And there's always been increasing dissatisfaction around the ICPC process. Most of you, if you are familiar with the ICPC, it is known for severe delays. We have started to work towards that by developing a national data system called the NEICE, and we'll talk a little bit about that later. However, the underpinnings of the child welfare system in and of itself also causes many delays in addition to the ICPC process. A child being placed interstate can wait up to 6 months to a year sometimes to be placed, particularly under this existing compact. And we are noticing that national stakeholders are finally seeing that there is a need for this particular compact to be reformed and changed. For example, the Conference of Chief Justices adopted a resolution back in 2017 urging all states to expeditiously pass the revised/new ICPC. Next slide. So what are our challenges? Now, this effort started many moons ago, the first state enacting the new ICPC in 2004. Of course, there have been many changes there. There was an economic downturn where many states had to focus on their basic and primary programs. And anytime you're trying to implement a revised compact, when there's already an existing compact, you run into challenges. Naturally, there is a resistance to change, particularly when you've been operating under one compact almost 50 years. We've had limited resources at the state and national level, and we also need a coordinated effort between the executive, legislative, and judicial branches. As I've already mentioned, Conference of Chief Justices adopted a resolution in 2017. However, if we could get succinct and coordinated efforts from all branches at the same time, I think we could be more successful in ratifying this particular compact with passage in 35 states. Next slide. The highlights of the new ICPC, what will really change? As I've already mentioned, we need a new legal framework for the ICPC. This will ensure timely placements across state lines, individual assessments for the suitability of families. It will provide the needed support systems and services. For example, states can contract with other states. We will have a national team that will assist with technical assistance, mediation, and other alternative services. It would also narrow the applicability of the ICPC to foster care and adoptive placements. As I mentioned earlier, some of the definitions in the existing compact are not clear and they do not resemble a sound legal framework. So there are questions around placements with parents and whether it is constitutional under the 14th Amendment. Also establishing jurisdictional authority. Next slide, please. Jurisdiction. This has been a big challenge under the current ICPC. The new ICPC will clarify that the retention of jurisdiction lies with the court and judicial officers rather than ICPC offices. Generally, when an ICPC office either approves or disapproves a placement, Most people believe that that should usurp a court's decision in making the placement. Now, albeit courts should take heed to any recommendations being made by ICPC offices because they are performing and conducting the assessments. However, jurisdiction from a legal sense and in a legal framework lies with the court. In addition to that, the new ICPC will allow courts to terminate jurisdiction as well. Next slide. Administrative procedures. This too is a big challenge under the current ICPC. However, under the new revised ICPC, we can establish the necessary rules for timeframes, legal and administrative processes. As most know who do child welfare, there's always an assessment process. And federal law, for example, through the Safe and Timely Interstate Placement Act, tried to put serious timeframes on the home study process. But in addition to that, there are other processes that are critical to the child placement continuum. Those being not only the home study, education and training, licensing, and background checks. The new ICPC will create an opportunity to establish uniform home study standards, education and training, licensing, and background checks, as well as provide the necessary equipment in order to expedite those processes in interstate placements. For example, in rural areas, many people have to go to local precincts in order to get fingerprints, background checks, and more metropolitan areas, sometimes they have live scan available. So this new compact will allow us to be able to use tools in order to expedite these processes. Next slide, please. Now we'll pass it off to Mr. Masters to talk to you about rulemaking. You're on mute, Rick.
I'm sorry. Thank you, Carla. And I want to reiterate what Carla has stated with respect to the need for change within the compact's legal structure. This compact, like a number of others similar to it, such as the Interstate Compact for Juveniles, was drafted back in the 1950s when administrative law as it exists today simply wasn't a thing. I mean, we did not have the types of uniform and more due process oriented rulemaking procedures within statutes that created interstate compacts. And as a consequence, the language in the existing compact concerning rulemaking, I think, is about one sentence and simply says that the compact administrators will be authorized to gather together and engage in rulemaking. But there's nothing there that would even come close to the Model Administrative Procedures Act, which most states have adopted, or the federal counterpart to that, which clearly provide a process by which requisite notice will be given to all of the stakeholders, those who regulate, as well as those who are regulated, and the opportunity to be heard through a vetting process that is more consistent with the way an administrative agency should work. And actually, that's what an interstate compact is when it engages in these types of activities, such as placing children across state lines. It's an interstate administrative agency, and it does need to be able to be responsive to the changing needs in this venue and in this part of the administrative activities among the states. Carla made the point about the Chief Justices being concerned about amending this document because it is so difficult for courts to understand exactly what they have the authority to do, and the rules by which we operate frequently need to be changed for such things as the opioid crisis and heroin crisis that all of our states are encountering, some more than others. But the Chief Justices are concerned with things that develop in that area where there's a drug addicted father and a drug addicted mother, and the placement may not be suitable for either parent, And many times the relatives live out of state. So they need to know what kind of authority they have, not only to be able to efficiently and quickly place these children, but to do so in a manner that protects those children's interest. And many times that's to place them with somebody that's across a state line. And so our processes are implicated in these kinds of crises, as well as the day-to-day ebb and flow of the process by which wards of the state, adoptive children and others that are eligible under this compact to be placed are done so, and that these placements occur in a safe and effective manner. So the rulemaking is extensively amended in this new compact that, again, substantially conforms to what I think most would be familiar with, the Model State Administrative Procedures Act, which gives ample notice for a hearing and an opportunity to be heard. And then these rules are published centrally by the rulemaking body, which is the Interstate Commission that's created by this compact. This is very similar to, as I said, the Interstate Compact for Juveniles, which the state of Maryland approved about 10 years ago, which again was an update of an older compact that still has very legitimate goals, but the way we do business has changed considerably over this period of time. And so there's a need to bring this instrument up to date into the 21st century. And of course, that includes not just rules, but the data system that we'll speak about a little bit later in just a few minutes. Next slide, please. The other reason, or one of the other principal reasons for updating the legal structure of the old, what we will soon be referring to as the old ICPC, once this one becomes effective, is with regard to enforcement. Again, the current compact that is being amended does not provide any specificity with regard to enforcing it. And like any other contract, in order to make it work effectively, you have to have some teeth within it that authorizes some activity that will encourage compliance with the compact. And that can be both with the use of a carrot, so to speak, figuratively speaking, as well as a stick. And we don't want to use the stick any more than we have to. And coercing people to do things is not something that is pleasant, but we have to cause our states to realize these are important processes. And if they're not being followed, there needs to be some compliance activity that will bring the compact states into compliance with the least amount of coercion necessary. Most of the time it will be positive, such as remedial training. Many times things don't happen the way they're supposed to because people are uninformed, and there's a great deal of turnover, as you know, among state government and regulatory agencies, such as child welfare departments have many changes within their workforce on a regular basis. So being able to train those who are responsible for carrying out this compact is important. Technical assistance will be offered where needed. Mediation where we have a disagreement among states. You know, sometimes it's not ignorance of what can be done, it's refusal to do something because somebody objects to it, but perhaps for the wrong reason. So we have a alternative dispute resolution mechanism in the new compact that provides for both mediation and, if necessary, binding arbitration, which is increasingly being used by state agencies as well as private agencies. And then finally, judicial action, which will be exceedingly rarely used, but the fact that that hammer, so to speak, exists, we hope will again incentivize states to do what needs to be done and to do what the state has promised to do by being a member of the compact. Now, this judicial action is not going to be a suit for damages. It's going to be a suit to compel a state to do what the statute requires, because again, compacts are not only statutes, they are contracts. And so if you have contractually obligated yourself to comply with the means by which the compact successfully and effectively places children across state lines, the judicial action would be in the form of an injunction to order compliance with something that the state has already undertaken to do. Next slide, please. We have some issues pertaining to tribes and tribal children that need to be placed under the compact. And while we cannot make rules directly with regard to federal sovereign entities, and there's some 500 recognized Indian tribes, we have not sought consent of Congress to add the tribes to the member states, because with 500 tribes, it would literally be the tail wagging the dog, because we feel like we can adequately respond to the needs of the tribal children by developing guidelines to work with the Indian Child Welfare Act, under the Indian Child Welfare Act, with the tribes, and to coordinate our activities through guidelines developed by this commission under the new compact. Next slide, please. And I mentioned the data system before. As I know all of you are aware, a system of regulatory responsibility, which causes people to have to be transferred across state lines, usually requires an effective data system. And without it, information that needs to flow between the states and among the states concerning people that are placed can't get there as fast as it needs to, which many times should be instantaneous. And so the need for a data system is without question one of the most important pieces of this new compact. And fortunately, our partners with the federal government and others have provided some support for the formulation of a data system, which Carla is going to describe in more detail.
So approximately 7 years ago, we applied for an OMB, the Office of Management and Budgeting Innovations Grant, which allows us now to develop the National Electronic Interstate Compact Enterprise, also known as the NEICE. This is the data system that allows ICPC to exchange files, make case decisions in real time. It has shortened timeframes as quickly or as short as 24 hours in some instances, particularly with private adoptions. And we are really seeing a lot of success with this system. However, this system does not resolve the main issue of ICPC. It is ancillary in looking at true ICPC reform. We do need to change the ICPC legal framework, as we've already stated. However, we are seeing great success with the NEICE. It started out as a pilot, and the federal government Administration of Children and Families, Children's Bureau extended the pilot to scale it out to all 52 jurisdictions. So we've received probably close to $5 million or a little more in developing this system. It also allows for interoperability, which allows us to interface with other necessary systems like court systems, TANF, Medicaid, criminal background checks. While we are not in that phase of development because we are still onboarding the 52 jurisdictions, the future looks very promising with the NEICE, and with reform around the legal framework, I think we can change the world of interstate placements. Next slide, please. Mr. Masters will continue talking about our governance structure. You're on mute.
The third area in which the legal structure is being adjusted, we've mentioned rulemaking, we've mentioned enforcement. The other part is perhaps the most important with regard to the interstate relationships that are formed under the compact statute and the ongoing nature of the collaboration that needs to be occurring among states. One of the problems under the existing compact is in many cases, there isn't the communication that should be directed toward the compact relationships in a formal way. We've got people obviously that are talking with each other to get a particular child placed across state lines each and every day, but under the current compact, there's no mechanism that's officially established within the compact to encourage big picture thinking, where we've got groups of state officials representing the compact states that will provide for problems within each state as well as between and among the member states. And so one of those ways of encouraging and institutionalizing, if you will, this collaboration is a state council. Now, this state council is not for the purpose of enforcement or rulemaking. It's for the important function of making sure the issues that are important in our state are being addressed nationally among the member states that are member states of the ICPC, which under the current compact is all 50 states. So the state council's goal, as it says here in the language in the proposed compact statute, will provide for coordination among the branches of state government concerning the state's participation in and compliance with the interstate compact activities, and create a state council of officials within each state for that purpose. And let's go to the next slide so we can see what those purposes are. First of all, to increase the visibility of a compact, of this particular compact, to state policymakers. Many of those within our legislative and judicial structures really don't understand that there is a compact or what it is supposed to do and how it's supposed to do it. It will also be an institutionalized mechanism for providing policy support and oversight so that we can give some guidance to our compact representatives in each state as to what the priorities are within each state. For instance, this issue with the chief justices and their concern about opioid crisis and related matters is one of those things that each state can weigh in on. How big a problem is this? What are we doing within the state of Maryland to solve it? And how do we relate to our other states within the region and nationally in trying to solve this problem? And also promoting ongoing interbranch awareness of compact issues, such as the one I just mentioned. Obviously, the opioid crisis is an example of something that concerns both the legislative branch and the judicial branch, as well as the executive branch. And so these kinds of problems hopefully can be brokered more efficiently and effectively through a mechanism of communication intended under these state councils. Next slide, please. Under the new compact, we still have a structure very similar in terms of its function, where the groups, a group of compact administrators, one per state, will gather together as they customarily have under the current compact. However, we have made this more clearly established under the compact as the official governing body. It really is not specifically described within the current compact in a way that gives states understanding as to what it is they're supposed to be doing. It will make these national commissioners conscious of the fact that they're not just they're compact administrators trying to do a good job in their state and meeting every so often to try to talk about it, but they are actually representatives of your state to serve as the person that is the contact person for all purposes related to the ICPC and to engage in establishing or amending the rules that will be made by this governing body in a very specific way. We've got the provision in here that national commissioners will be appointed by the head of the Human Services Administration within the state, which will have responsibility for the child welfare program in each state. And each state retains the right to determine the qualifications of who that representative should be, although certainly it's recommended that that be someone obviously that is within the Human Services program, and to determine what qualifications that person has is obviously the function of each state. Next slide. So Carl and I will both answer anticipated questions, such as what happens during the transition. The legislation will make its way through the states, just like any other statute, although as those of you on this committee know, an interstate compact, because it is contractual in nature, needs to be substantially similar in every material respect. In other words, you can't substantially alter it because you're entering into a contract with all the other states to do business with regard to placement of children in a uniform and certain way. That being said, this still is to go forward as legislation, as with any bill. And once the two chambers of your legislature pass it and the governor signs it, it will become effective. Because we are replacing a compact that has 50 states at the table, it was felt that we ought to at least have 2/3 of the states on board before the new one becomes effective. So up until the 35th state will enact this compact, the current one continues to apply. So as you can see, we're still a considerable distance away from the finish line, but we're hoping that we can move this process as quickly as possible. One of the benefits of being one of those first 35 states to enact the compact is this group will totally re-examine the existing rules and see what's needed to effectively amend the existing rules or add new ones. And if you're one of that first 35 to adopt, certainly it's to your advantage because you'll have a greater opportunity and a earlier opportunity to be part of that rulemaking review. Next slide. Carla, I'm going to turn it back to you.
Thank you, Rick. I would like to correct the record. In the beginning, I think Delegate Carr mentioned there were 12 states that had enacted the new ICPC. There are actually 13 now, and I wanted to correct that for the record. They are Ohio, Alaska, Delaware, Florida, Indiana, Kentucky, Maine, Minnesota, Missouri, Nebraska, Oklahoma, Wisconsin, and Louisiana. Now, we're happy to entertain questions.
Thank you very much for that presentation. So far we have questions from Senator Casserly and then Senator Carosa.
Can you hear me okay? All right.
Yes.
So thank you for the presentation. So you answered my first question, which was basically where do we go from here? And my understanding is based upon what you just said, we'll see a bill introduced possibly this year. I'm not sure based on, we don't know what's introduced this year, but in any event, we'll see a bill at some point. That's our next step. So I'll take that as the answer to my first question. The next is, the compact, both the existing and the proposed, do those relate to children in divorce status, separation status, adoption status, and any other statuses that maybe I'm missing? Or is it just a particular area?
It is a particular area. It's normally children who are under the child welfare system and not domestic relation situations or family domestic relations. So children who are either wards of the state or maybe not wards of the state, but have been removed from the home due to abuse and neglect, or have voluntarily been placed with the child welfare system. And it also covers public and private adoptions. For purposes of residential treatment facilities, we will only be asking for notice under the new compact. And as we stated during our presentation, we're looking to clarify applicability of the ICPC to foster and adoptions.
Okay, so it's foster, adoption, those are really what we're talking about.
Yes.
Those are the kids being impacted, right?
Yes. Yes.
Okay, and then so I'm trying to understand how I mean, foster care, a child comes into our child welfare system here in Maryland. Can you give me some example? How often would that be that this becomes a multi-state issue? I mean, a child's been removed from the home in Maryland because parents aren't being good parents, whatever have you. And so now it's an interstate matter because just give me a scenario, like the most likely scenarios. I mean, I know divorce and separation, parties separate, one goes to one state, one goes to the other. What's the most likely scenario we're dealing with on these things?
Well, when a child is removed from his or her home for purposes of abuse and neglect, or if there is some additional inquiry, interstate is always a potentiality or a possibility, depending upon where the child's familial resources and other family resources are located. In addition to that, there have been several pieces of federal legislation that require states to include options or family resources that are based interstate, because there have been biases with intrastate social workers and caseworkers that would not want to place interstate. So they would prefer to place a child with a foster care family or keep a child in a group home because of problems with the ICPC process. And we do recognize that the ICPC process through the years has been a very slow process. However, the Adoptions and Safe Families Act many years ago included language that require consideration of interstate placements as a part of family finding. And as I mentioned earlier, the Safe and Timely Interstate Placement Act has also loosened some of the restrictions where it allows judges to communicate with each other across state lines and other options that would promote using interstate placements. So to answer your question, anytime a child comes into care, once a social worker or a caseworker starts the family finding process, if an interstate resource exists, it should be considered. We do not have hard data right now around how many states or how often states are looking at interstate placements, not on a collective, a comprehensive basis, because we are still in the developmental processes of NEICE, but individual states can speak to that. And I'm sure your Maryland Health and Human Services office can provide that data for you.
Okay, and then just one final question. So Maryland appoints a National Commission member, and that person, I guess, best case scenario is one of 50 or more, I guess may have some for territories and the like, of national commissioners. And those are the people that adopt the rules, right?
Right. I'm going to defer to Mr. Masters in answering this question.
So I mean, basically my question would be, based upon that understanding, our designee could vote no on a rule vehemently and be adamantly opposed to a rule, but yet they're outvoted, 20 by 29 other states. And so then we would be compelled to do child placement in accordance with the rules that our state representative didn't support. Is that right?
Yeah, Senator, you're correct. Although it's usually the case that these rules don't even make it to prime time unless there's a substantial consensus developed among the group. I mean, it's difficult to get 50 people plus several territories to agree on anything, and so without a consensus, most of these rule amendments are never going to pass unless they've already developed sort of a groundswell of support. And I can speak from experience because I also advise the Interstate Commission for Juveniles, which Maryland is a member of. And it's typically the case that once a rule gets before the entire group and has made it through all of the committee processes that it's put through with stakeholder review and hearings, once you get before the entire commission, it's rare to have one that's defeated. But in answer to your question, it is true you would have to live with that rule. That there is a provision that the legislatures could by majority vote, overrule that and strike it. Certainly, there's a provision for administrative review in the judicial system if a state wants to go to court over it or otherwise challenge it. But failing those alternatives, you'd have to live with the rule, even if you were opposed to it in terms of voting.
So just to restate that really briefly, if the national commissioners come up with a rule that Maryland and some other state, let's say Maryland in particular, we said we don't like that rule at all, that violates our public policy. General Assembly meets the following session and says, we're adopting a statute that overrides that rule. We could do that, and then our state would not be subject to that rule. Is that correct?
Well, if we had a majority of states that among themselves decided to override it legislatively, yes, you could do that, but it would be difficult because I think the way we've got the review process set up, they would have to vote by majority. So I think you would probably have to challenge it judicially in order to overcome it, or certainly you're at liberty to withdraw from the compact. I think you'll find if you talk with your commissioner for the juvenile compact that they've been functioning for about 20 years now, and I don't believe we've ever had a state withdraw or file any kind of a legal challenge to it. But it would be
so under the current rules, is there rulemaking authority that we just described? Does that exist and it's already being exercised?
Yes. And it's limited, of course, by the terms of the statute to this interstate process by which these children are moved across state lines and the procedures by which that occurs. So you're not giving us a blank check to do anything we want with child welfare. You still run the process the way you need to do it in Maryland. But once you cross the state line, we have procedures that flow from the compact. Many of those are already in effect, and a lot of those will simply become reincorporated into the new rules, but we will make appropriate amendments or additions to make sure we're being more effective.
So specifically the areas in which we're expanding rulemaking authority are what? The significant ones?
Well, again, the jurisdictional issue is one. We've got some conflicts with some of the uniform laws concerning child custody and jurisdiction. We've got issues pertaining to these things like opioids or other problems where we're needing to have emergency placements that aren't happening fast enough. I mean, if somebody has to wait for several months to get a kid out of a dangerous home, that's just not acceptable. So a lot of judges are trying to find ways to go around the compact because we're not being as responsive as we need to be to these and other issues. So really, it's more designed at effectiveness and timeliness than any other single thing. And Carla may have one or two other issues in that category.
Before I hand it off to Senator Carosa, I just wanted to ask a quick question. Do we know which is the most of the 13 states that have adopted the compact? Which one or ones have adopted it most recently?
I do not have that information in front of me. However, I can send that over to Scott.
Thank you. All right, Senator Carosa.
Thank you.
Okay. First of all, thank you for the presentation. And I wanted to follow up, and not sure which of you would like to respond to it. From my experience with working on other compacts, the number of states that agree to move forward is much lower. And I see that the threshold here is 35 and you're at 13 now. So I guess my question is, since there seems to be some value in replacing the compact when it comes to responsiveness, the case that you're making for a new compact, is there anything that we can do at the state level to have some benefits without, waiting for the rest of, without reaching that 35? In other words, it sounds to me on some of the, I don't know if it was technology or some of the benefits of the compact that, if we're at 13 and you need 35, this is a bit of a long road. So, I guess I'm trying to be a little bit more immediate. If there's some values of this new replacing this compact, is there anything we can do and move forward on without, that we can do on our own as a state without having the whole compact agree?
Rick, would you like to address that first, or would you like?
Well, why don't you deal with the substance and I'll talk about the procedure. Sure.
So first, to answer your question, we do have other tools available for working with your immediate neighbors called border agreements. And for counties that are not only close in proximity, but adjacent, to each other because we normally require touching. We are considering whether we should loosen that restriction in light of mobility and some of the needs of the day. However, there are several states that have border agreements with their bordering states. So that is one option. However, because interstate compacts require interstate cooperation, we are best served by reforming the current ICPC, but that along with the NEICE, which of course is the new data system, and Maryland has joined the NEICE, and along with border agreements and the regulations that we've amended in 2010, 2011, and 2012, we are doing our best to meet the needs of the day for the child welfare system and interstate placements.
And if I could, before you, the follow-up, just since I have a district that the southern part of my district borders Virginia and the northern part of my district borders Delaware, and I understand the ideal situation is the replacement, but anything that we can leverage on existing agreements, I think would be very helpful to our constituents.
Right, great. And I do want to clarify, they must border. So for example, we recently received a question if states that border can have agreements throughout the entire state. So for example, when you think of a state like California or Texas, having a border agreement throughout the entire state, you can travel 10, 11 hours and never leave the state. So we like to be clear that they must be bordering counties and adjacent and touching normally in general. Also, what could help within your own state is training with your judges, training caseworkers, compact administrators, ensuring that you have the necessary tools to expedite review and assessments, like I mentioned earlier, live scan for criminal background checks, to ensure that your education and training is available maybe virtually. And of course, since we're all living in the midst of a national pandemic, we're all learning virtual and using virtual tools more often now. But even after the pandemic, making education and training and licensing available where rural areas as well as metropolitan areas will have access quicker.
Thank you.
Yes.
All right. Thank you very much, Ms. Foltz and Mr. Masters. We're going to move on to the next segment. Seeing no more questions, you're welcome to stay on the call as long as you like. So for the next part, we have the Maryland Department of Human Services, and I wanted to hand it off to Lauren Graziano, and you can introduce your panel and start.
Hi, good morning, everyone. Lauren Graziano on behalf of the department. I'm the Director of Government Affairs. Just quickly wanted to introduce our panel, and we're also happy to be here with you this morning. So with you today, we have Michelle L. Farr. She's our Executive Director for the Social Services Administration. She's going to be walking you through our presentation on the ICPC. With her, she has a member of her team, Mr. Charles Gentleman, one of our resident subject matter experts on the ICPC. And we also have with you this morning, Ms. Janet Hartshee and Ms. Kathy Crosby. They're both Assistant Attorney Generals within the department, and they will be here to assist with any questions you may have. With that, I will turn it over to Michelle to walk you through our presentation.
Thank you so much, Lauren. And good morning, everyone. Thank you, Senator Carter and Delegate Carr and committee members for allowing us an opportunity to provide information regarding the Interstate Compact for the Placement of Children, which we will reference from this point on as ICPC. But I also want to thank our APHSA partners, Carla Foltz and Rick Master. And some of what you'll hear from me today will be basically sharing in alignment with what they've provided already. And so I also want to thank my colleagues who are on the call, Kathy Crosby, Charles Gentleman, and Janet Hartshee, who will be assisting with answering any questions that you may have after our brief presentation. Next slide, please. Excuse me. So as you heard, the ICPC was drafted nearly 50 years ago, and the current ICPC Compact was established in 1960 with the intention to ensure the protection of foster and adoptive children and their safety, right, across the state lines. In addition, however, it also allowed for services to be provided to parents, to relatives, to prospective adoptive parents, and other placement resources in pursuit of permanency as needed. And that would include Washington, D.C., as well as the U.S. Virgin Islands. Next slide, please. So when does ICPC apply? You've already heard that a youth under court's jurisdiction seeking a placement outside of the state of Maryland would be the candidate for an ICPC. And that child is proposed to be placed or adopted across state lines by a state agency, a private person, or an attorney. And we partner with our receiving jurisdictions and their placement agencies, as you've heard in the prior presentation. Next slide, please. So when does ICPC not apply? It doesn't apply if the state of Maryland does not have jurisdiction over the youth and the parent or relative is legally free to make a placement plan for the youth accordingly. And that would include any out-of-state arrangements. The child is basically exempt at that point from the compact. However, the other thing that I would like to remind you of is that any placements that are purely a medical facility or an educational institution, such as a boarding school, which is not considered a substitute for parental care, the compact would not apply for that youth either. As well as you see here, placements with non-custodial parents would not apply to the ICPC. Next slide, please. So you heard a little earlier today about the new ICPC legal framework. I wanted to touch on, again, some of the items that were shared earlier. One, again, is the timely placement across state lines. As you've heard, there are substantial delays in our being able to place youth across state lines with the current ICPC process. The other is the provision of needed supportive services. This is critical because as our youth are being served, it's important that they are served with a treatment modality that's going to really meet their needs. Another that I want to bring to your attention, and you heard earlier, was establishing clear rulemaking authority and providing enforcement mechanisms. This again is critical, and it really speaks to having a collective and a cooperative relationship with other states to ensure that we are all adhering to the ICPC framework. And lastly, I want to mention again, clarifying state responsibilities, and you heard that as well in the prior presentation. So we definitely concur with the information that has been shared thus far. Next slide, please. Here you will see a comparison of the new ICPC to the current ICPC. It is redundant, I believe, to what you've already heard. I do want to though stress that the requirements seek to promote timely and seamless placements of children across state lines. The few of the benefits, as you see here, will allow for provisional travel, will also allow for provisional placement with relatives, something that you heard in the prior presentation that can sometimes be a challenge. But in addition, the new ICPC will facilitate a smoother transition for placement if in fact the child requires a placement in a residential treatment center. And when necessary, that child, of course, must be in the custody of the state. If again, a parent has legal authority to place a child in a residential treatment center, the ICPC would not apply. The next slide, please. And so you heard, I believe, Rick Master talk about the actions needed. This is where we are at today. Enacting a new legislation would allow Maryland to implement the new compact once 35 states have passed the new compact. And she just corrected and updated, and so we'll update our slide to represent that there are currently 13 states that have passed statutes to allow for future implementation. And there apparently may be one state now where there is an introduction of legislation to hopefully adopt the compact as well. There was a question that was posed, and I did want to address a question with respects to border agreement. Currently, the state of Maryland has a border agreement with Washington, D.C. We do not have a border agreement with any of the other states. And so the next slide, please. There you have it. I will go ahead and take any questions.
Okay, thank you very much. So if you have committee members who have questions, send me a private message. I will just start by asking, does the department have any plans to introduce the compact as a departmental bill for the 2021 session? And if it were introduced, what committees would it go to? I'm assuming it would go to Judiciary in the House and JPR in the Senate. Can you comment on those two things?
Lauren, I'm going to defer to you.
Sure. So great question, Chairman Carr. So I think this will be ripe for consideration probably in the 2022 session. As you've heard multiple times today, the statute does not go into effect until 35 states have ratified it. And I think some research needs to be done in terms of how we incorporate that into any bill that we draft, right? How we trigger that once the 35 state threshold is met. There was a very, very recent Court of Appeals decision that just came down regarding the ICPC and its applicability to non-custodial parents. So I think we want to ensure that we're being mindful of any bill we draft is responsive to that or incorporates that decision as well. So we're looking at it, and I would say probably next session, the 2022 session, this will be ripe for consideration.
And if and when that bill gets introduced, do you know, would it go to like Judiciary in the House and JPR in the Senate? Because I guess the existing ICPC is in the family law section. So,
Lauren, you're muted.
Sorry, thank you. So yes, typically we are most frequently in front of the Judiciary Committee in the House and JPR in the Senate. That's correct.
and I mean, I guess being a small state, the new revised compact being of more useful to us than a big state like California. So if, let's say, a member of the General Assembly were to go ahead and introduce this, would DHS be, how would DHS react to this? It sounds like you all want to wait until 2022, but if a legislator wanted to move more quickly, how would DHS react to that?
So I think we'd certainly want an opportunity to collaborate with the bill sponsor, but you know, it's certainly, if there was an appetite to move on this more quickly, I think we'd be open to having those discussions. Mr. Chairman, you're muted if you're speaking. Sorry.
Sorry about that. So Senator Carrozza has a question, but I'll stick one in real quick before she starts. Is are some of the functions under the ICPC delegated to Montgomery County, in Montgomery County? Because I know that Montgomery County does have jurisdiction over certain human services type functions, but I didn't know how that affected things like foster care and things that would fall under their ICPC.
That might be a question best suited for one of our AGs that is on, either Janet or Kathy, if you would like to address that. Looks like Janet is ready to go.
So if Montgomery County needs to place a child out of state, it would still go through our office and our central office in Baltimore. So it wouldn't be that they were doing that separately. Montgomery County would still put that request to Mr. Gentleman and for processing. Does that answer your question?
Thank you. All right, Senator Carrozza.
Hello, thank you. I am So,
Okay. You were unmuted, but now you're muted. So we need to re-unmute you so you can ask your question. Yeah, still cannot hear you, Senator Carrozza.
I think that might be one of the DLS staff has the.
okay, how about now? Thank you. And I'm going to follow up on Delegate Carr's line of questioning, and I appreciate that update that you provided that we have a border agreement with DC, but obviously not some of our other bordering states, Virginia, Delaware, Pennsylvania. So I guess my question would be, since this is a long process with 35 states, is there any value to looking at the border agreements with our neighboring states as a way to better serve our constituents?
Michelle, would you like to?
Okay, there I go. Yes, I would. Thank you so much, Senator Carrozza. I would say yes, it is something that we would be interested in having dialogue with our other neighboring states. I will say the benefit of having the Interstate Compact is because of the collective and the cooperative agreement that is across all of the states. But there is an opportunity absolutely for us to pursue. I'm not sure if that's something we have done in the past. I will definitely have conversation with the SSA team to see if this is something we can move forward with, of course, with our legal partners as well.
Thank you. And I'm sure I, along with others on this Zoom call, would, enjoy working with you on it.
Thank you.
All right, looks like Delegate Resnick has a question.
There we go. Thank you, Mr. Chairman. And I apologize to everyone for being very, very late. I had a hard time finding the link. And maybe this was addressed earlier, and I appreciate the need for the Interstate Compact. But can anybody hear me?
Mm-hmm.
There we go. Okay.
I can hear you. Your volume is a little low.
Interstate Compact. However, as the folks from DHS know, this has been a particular issue I've been focused on for some time, and trying to limit the number of out-of-state placements to what is absolutely necessary has been a particular interest of mine. So my question is, even with the compact and with the renewing of the compact, where are we in terms of bringing back kids into facilities that are in Maryland so that they are closer to their homes, closer to their families, and using the Interstate Compact for placement at the most minimum needs necessary?
Thank you for your question, Delegate Resnick. First, I will say that our agency, as I'm sure you know, are always looking to ensure that our children are remaining within their home environments and within their communities as long as they can remain there safely. So that's first and foremost our effort. Secondly, if there is a need, unfortunately, to separate a child from their family environment, then we are looking for our kin, as we are required to do, within our state and within their families, as close as possible, right? So we're looking at our kinship as our next level, if you will, of transitioning our youth that have to be separated. And so we do look at the Interstate Compact, and I think you heard from our previous presenter, if you were on, that when we are required to look at our relatives, we're looking at the relatives of youth, not just in state, but out of state as well. And so we will continue to do that, but that of course would be something that we look at in terms of our priorities. With respects to where we are now with our returning our youth, we are still in a developmental stage of planning for that. as we are looking at not just returning our youth, but also ensuring that the youth that are currently in our state are remaining in our state when they require the types of placements that are sometimes very difficult to access.
If I can follow up, Mr. Chairman, thank you. Ms. Farr, thank you for that. I passed legislation, I believe 4 years ago, 3 or 4 years ago, that would expand the rights of DHS to have new facilities in the state for the very purpose of bringing kids from out of state back into the state. And so in that 3 to 4 years, I've been hearing we are in the planning stages of that. So what I would like to know right now is exactly how many kids do we have out of state, and at what annual cost to the Maryland taxpayer are those kids out of state?
Yeah, Delegate Resnick, if I may, I'm familiar that at one time we had as many as a few hundred kids out of state. I know those numbers have come down significantly. I can't tell you exactly, but I can tell you it is less than 40 at this point. We're happy to provide you the exact number as a follow-up.
We don't know how many kids we have out of state right now?
I cannot tell you the exact number off the top of my head. It's somewhere in the ballpark of 30.
Okay, thank you. I would appreciate that, along with the cost of those contracts to those out of state facilities for an annual basis. Thank you. Thank you, Mr. Chairman.
Okay, thank you. All right, do other members of the committees have questions? All right, well, seeing none, I think this concludes. Oh, I'm sorry, somebody does have a question. Who has a question? Is it you, Delegate Resnick? So.
Mr. Chairman, it looked like maybe Senator Augustine had a question.
Oh, he told me that Delegate Resnick asked his question.
Okay.
Senator Augustine. All right, great. So thank you very much, Ms. Graziano, Ms. Farr, other members of your panel for your presentation. We greatly appreciate it. Thank you very much to the staff for putting this together. My co-chair, Senator Carter, do you have any parting words? I know you're dialed in over the phone, so I don't know how to unmute someone over the phone. But in any case, we'll be wrapping up our work in terms of our annual review of interstate compacts. So check your email for emails from staff. And again, thank you very much and have a great day.
Thank you.
Thank you so much.